Mr. Is it Bowman?
Yes, ma'am.
Hi, can you go check with your colleague and find out if we can get an update? I understand it might take some time to actually get someone connected, but if we could get an update about what we're gonna try and do, I'd appreciate it. Thank you. Ms. Merchant, Ms. Sierra Bergdorf.
That's our paralegal job, and, so we were trying to figure out the best way to share our screen and exhibits and.
Totally fine, that's what I assumed, just wanted to confirm,
Yes,
that was who that was. And yes, that is the way that we share evidence in the courtroom, is to share your screen on Zoom.
and she is much better than I am at putting.
Isn't everybody better at sharing evidence than lawyers?
It's a certain, and I also think it's a certain age. Better, I will age myself, I think a certain age is better. But that just may be my learning curve.
Thank you for your patience. So we were able to get a court reporter. We're
Okay.
sending her the email with the Zoom link, and
Yes,
she'll be logging on as soon as she gets it.
Excellent. And Ms. Monroe, correct?
Yes.
Thank you so much. No problem. I think I've only seen y'all on the Zoom screen
Yeah,
before, so.
It's awesome. You guys play. No, I'm on 74. Oh, no. Okay. Hey, Chris, it's Hunter. Can you change me over to remote 74 on the boardroom? All right. Thank you, Chris. Bye.
She should be logging on any minute now.
Thank you.
Just have a drink. Have a drink.
Oh, yeah. Jay's not here today, but normally she walks out with baskets and hands people water bottles, so she's an excellent host.
I like it. Well, Mr. Merchant is great at going to the vending machines.
Good morning.
Good morning, Ms. Brown. How are you? Well, thank you for appearing on such short notice. Or whenever you're ready to go, what I will typically do is I will just start calling the case and ask the lawyers to make announcements so that you'll know that we're starting. Anything you need from me, or are you ready to get started, Ms. Brown?
I'm ready to get started. And if there's anything I find I need, I'll ask at the end. Thank you.
Okay, thank you. Okay, this is going to be a hearing in the matter of the Merchant Law Firm versus the Fulton County District Attorney's Office, Fulton County, Georgia, Fani Willis individually, and Fani Willis in her individual capacity. Case number 24CV001325. If I could start by getting announcements for the parties, starting with counsel for the plaintiff.
Good morning, Judge Ashley and John Marchant from plaintiff.
Okay,
And at
and
council table is our paralegals here for.
thank you. And counsel for the defendants.
Good morning, Sandy Monroe on behalf of the county, on behalf of the DA's office, and Fani Willis in her official capacity, along with my second chair, Brad Bowman.
Okay, thank you. And just to make sure the record is clear, we had a hearing on September the 5th. At that hearing, oh, I'm so sorry, ma'am. Please make your announcement.
Good morning, Your Honor. My name is Andrea Allaby. I serve as legal counsel in the Fulton County District Attorney's Office.
Mhm.
I have filed a limited entry of appearance with regard to 5 motions to quash non-parties and a motion to release / quash a 6th party. So
Yes.
with the court's convenience, if I can be heard on those.
Understood. And tell me how to spell your last name.
ALAB as in boy, Allaby.
Okay, thank you. Just like it sounds. Okay. Okay, so what I was saying, just to sort of get us to where we all are today, we had a hearing on September the 5th where the court ruled verbally on the motions to dismiss. And so just for the record, as I think Ms. Monroe noted in her announcement, the court has verbally announced that Fani Willis in her individual capacity has been dismissed from the suit. I apologize for not having you a written order yet, but I had to stop and turn my attention to some other things. I was also at a conference, and so I expect I'm almost done with that order, and I expect that y'all will have it today or tomorrow, depending on how things go. But just to reiterate that I have already ruled on the motions to dismiss, denying the motion to dismiss as to the district attorney's office, Madam DA in her official capacity, and Fulton County, Georgia, and then granted the motion as to Ms. Willis individually. Where we are now, at the hearing on September 5th, so the hearing on September the 5th was originally noticed as an evidentiary hearing associated with understanding some of the underlying issues of efforts to comply with the requests. And that didn't occur because the motions to dismiss are meaty, right? They involve lots of argument. The parties needed to make that argument. The court needed to be educated about what those issues were. And it took a while. And so We did not end up hearing from the witnesses that day, although my understanding is that most of them were aware, present, and prepared to testify if called upon. And that although I spoke inartfully at one point about them being released from their subpoenas for that day, I made clear, I clarified that what I meant was they were excused for the day and had not been excused from the subpoenas that were served upon them. I've reviewed the record and I'm not aware of any motion to quash the subpoenas that were served. I understand that either or both the county attorney's office on behalf of the existing DAs or Ms. Allaby, is that right?
Yes, ma'am.
On behalf of the non-parties who were subpoenaed have taken the position that either or both those subpoenas were for the production of documents, not for appearance, and or that any new subpoenas for appearance at today's hearing have not been served on those non-parties and or the defendants. I will note that I received a motion to hold Ms. Willis in contempt for lack of compliance with the subpoena for today's appearance. Given that, to my understanding, unless and until Ms. Willis is called to the stand and refuses or fails to appear, if ordered to do so, she's not in contempt, and so that motion is premature. Followed by that, and the reason I'm reciting all this is because the last thing in the record right now is my most recent order that I think was entered on Tuesday. And so none of the flurry of filings have actually been accepted into the record, although I am aware of them because y'all provided them to me. So following that, I received a motion to quash the subpoena to Ms. Willis as the DA. And then subsequently, I got a response brief from the plaintiffs. And then subsequently from Ms. Allaby, I received motions to quash or to be excused from, I think 5 or 6 subpoenas. And so we need to figure out where we are and what we're doing today regarding, one other issue I wanted to put on the record, that one of the witnesses, just to make sure everybody is aware of that, one of the witnesses, Mr. Kevin Armstrong, he reached out because Mr. Armstrong historically was I'm not exactly sure what his role is in the district attorney's office now. I know maybe a DDA, but historically he had appeared in my courtroom as an appellate attorney on behalf of the DA's office. And so he reached out to my litigation manager and notified her that he had an appellate argument in front of the Court of Appeals this morning and asked to be able to resolve that conflict by going ahead, of course, with his appellate argument and then appearing today, which informally my litigation manager told him by email was perfectly fine. So just because there was not a record of that, I'm sure y'all were all probably aware of it, but I wanted to make sure that there was a record of it. Okay. So having started with the fact that I'm not going to entertain the plaintiff's motion to hold Fani Willis in contempt currently, I think where we need to start is with the motions to quash, because what I anticipated, but for those motions, was for the plaintiffs to call witnesses. Now, one thing I do want to share with y'all is that it was my intention, we're going to sort out these issues in a moment about what witnesses are here and why they're not here and if that's okay that they're not here and all that good stuff. But I will say I was going to point out that while I'm a big believer in letting lawyers try their cases and put on their cases the way they go, I also come from a civil background where it's pretty well established that we don't harass the CEO of a company for information that can be provided by the head of the human relations department or some other similar analogy that I'm not coming up with as efficiently as I should. I say that to say this. If we reach witnesses today, I think everybody should be prepared for the fact that it's not my intention, Ms. Merchant, Mr. Merchant, to let you start by calling Madam DA Willis, because the inquiry here should be about, as I understand it, the receipt of the request, the processing of the request, and the efforts made to comply with that request. And as a practical matter, we all know that while Madam DA may be involved in that process at some point, she's not the first line that's going to answer the questions or have direct knowledge. And so we can hash that out as we move forward. But I say that to start with the idea that there was always a possibility that we might never have reached Ms. Willis as a witness today. But now, everybody's filed their motions, and so we have to reach these issues today. So with that, I think I'm gonna stop talking in a moment and give y'all a chance to tell me if there's any procedural issue or preliminary matter we need to take up otherwise. But my intention is to start with the the defendant's attorneys and Ms. Allaby's motions to quash so that we can deal with those issues first, because essentially in terms of at least what we're doing today, they could be outcome determinative.
That works for the planning judge. And just so you know, our intention was to call Dexter Bond, who is the open records.
Whose job it is to answer Open Records Act requests for the DA's office, yes.
That was gonna be our first witness. Our second witness was gonna be Jeff DeSantis. His job is media relations, and because, and I can go, when I go through and explain why that was relevant. And then Shalonda Miller from the county attorney's office, whose job is also open records. Those three witnesses, and as I told Ms. Monroe, the other witnesses would be potentially, depending on what those people testified to. So it would really depend on what they testified to, but our intention was to call those people first. And you know, we're ready to respond if you'd like us to respond to the states, not the states. Oh, I guess, so I'm gonna call the DA the state, and then the district, then the county attorney the county. I guess that might be easier.
Well, I think actually, because this is as good a time as any to remind us all that this is a civil case.
Right.
It is not a criminal case. And so I too have had to remind myself, but I think maybe to keep the record as clean as possible, the best way to do this is that Ms. Monroe and Mr. Bowman are defendants possessive plural counsel, and that Ms. Allaby represents the non-party subpoenaed witnesses. Y'all are of course the plaintiffs, which makes it easy.
Right, okay.
So let's go from there.
So I'm ready to respond, and I think the non-party defendants, non-party witnesses in this case, their motions argue that the burden shifts to us, and so we're prepared to proceed with those first.
Okay. Any other preliminary thing or matter y'all want to address, Ms. Allaby or Ms. Monroe, on behalf of defendants and the witnesses?
Nothing additional.
Okay. Okay, so. Go ahead, Ms. Mitchell.
Thank you, Jeff. Is it okay if I stand at the podium?
Yes, please.
Okay, I wasn't sure, there's a lot of equipment, so I just want to make sure.
Yeah, no, for purposes of the cameras, they're everywhere, so.
Okay.
And the audio is all linked to the podium, so it works better that way anyway. Go ahead.
Great, thank you so much, Judge. Okay, so just to start, the motions to quash that were filed by the district attorney witnesses, in this case, their motion argues essentially that it was oppressive and harassing. They state in their motion that we subpoenaed 12 other DA employees. I'm not quite sure where they got that information from because we've never subpoenaed 12 DA employees. They say that repeatedly in their motions, that's wrong. There are 6 DA employees that were subpoenaed, and there were 6 motions that they filed. So I think they know that there were only 6 people because they only filed 6 motions, but I'm not sure. So I just wanted to clarify that because the number seems to be part of the argument about how oppressive it was. It says 12 separate subpoenas for 12 other DA employees. The separate subpoenas, as the court knows, we sent subpoenas originally for the first hearing date, and that hearing was an evidentiary motion. It was more fashioned about the motion to dismiss. So we focused on one primary issue with our open records request, the critical mention documents, so that we could have that ready for the court. Once we learned that this was going to be a full evidentiary hearing, and this was essentially the final hearing in this case, we knew that we needed additional documents, and these are the same documents that we've been asking for 9 months. So they're not new. None of this is new. None of this is oppressive and new and us sending it to them on the last minute, Judge. these it's 6 separate subpoenas. It's 2 per witness, a witness and a motion and a production of evidence. So it's only 6 people. The the non-party in their arguments first said that our first subpoena was compliant, the September 5th subpoena. They're saying that they have produced all responsive documents.
Right, and that is supported by the certifications of business records that were filed that are actually in the record from, I think, immediately before that hearing on the 5th, right?
Yes, Judge, we filed those into the record as well. And the issue is that's authentication. So that's not the scope of the documents. That's not us being able to ask questions about, are these really everything that you have? And just by way of example, just yesterday, one of those people filed a new certificate that said, oopsie, I found another document, because I sent that document to them. So Ms. English, who was a county employee, when she certified 197 pages and said, I sent all of it, I said, oh well, that's ironic because you didn't send this. So she said there were no documents, and then I had one of the documents, and so they had to recertify it. That is why we need to be able to question the witnesses about that. And that's why they didn't produce all responsive documents. That's false. They did not. We have documents that are responsive that were not produced, that we have submitted into evidence in this case. So we have a right to question the witnesses about that. So that's back for the September 5th subpoena. Moving on to the September 19th, the one for today, their motions to quash admit that they received it. They received it by email. They're claiming that it's defective because they haven't picked up the certified mail copy. Well, they could leave that there as long as they want. We are members of the bar. They are county employees. They're tax-funded paid employees that work in this office. Everybody was still under subpoena from the last hearing. This is about documents.
Well, let's be specific though, because part of their argument is that the last subpoenas that were served for September 5th, as I understand it, their arguments are twofold. One is that the argument was for the production of documents, not for the appearance of a witness, which this happens pretty routinely. You send somebody a subpoena and what you need is for them to give you the documents, and once they give you the documents, that you consider their obligation of that subpoena satisfied. I'm not saying that that's the rule, I'm saying that's typically how it's done. So one argument is that it was for the production of documents, not for them to appear as a witness. And number 2 is, to the extent that it was for the production of documents, which you've already addressed, they comply by saying either here are the documents I have, or I don't have any documents. So start with, because I think it's clear that the newer subpoenas that you sent, at least by representation, were very clearly for appearance to testify at a hearing. So start with addressing the issue of whether or not the prior subpoenas that nobody objected to were in fact sufficient to require their appearance.
Well, because, and we addressed this. So the reason they're sufficient is we addressed this at the hearing, and it was all by consent. We asked, and the reason that we asked was because we were afraid that they would try to evade service. And you asked if we were okay with an expedited discovery process. We waived our right to discovery. We waived our right to do depositions in this case. We waived our right to do notices of production. We did that because the county, the defendants, agreed to an expedited hearing, and they agreed that the 19th would work. So we did that in good faith, believing. They said they were not going to file motions to quash. Mr. Bowman at the end said he was not going to engage in that. We asked that. We asked that on purpose. You cleared your calendar. You gave us dates that were available. We all talked about the dates. We all did that in good faith. Had we known at that point, had they told us, hey, what we're really going to do is we're going to agree to this date and then we're going to hide from your service so that you can't actually subpoena any of these witnesses. That's what we're going to do. Then why would we have agreed to that? You were offering us an expedited hearing date. We were trying to minimize costs and get the documents. We've been trying to get them for 10 months now. We're just trying to get the documents. And so that's why. I mean, the subpoena, it was clear. Everybody in that hearing agreed that the subpoenas were going to continue. You even mentioned to them, are you really going to make them reserve it? That just drives up the cost. Then, Judge, just so you know the history, so that happened at that hearing. Us being extra cautious, emailed Ms. Monroe immediately after that hearing. And I said that I was worried about it, and I asked them specifically if I needed to reserve these subpoenas. And they told me that if they were properly served, we did not have to reserve them. Nobody has said that our original subpoenas were not properly served. They said we did not have to reserve them. She said that by email. Then she backtracked and said, oh wait, actually the DA's office, you have to reserve them. We can't accept service for the DA's office. So this is like a week ago. This is after we've agreed to this expedited hearing. This is, and we emailed them and said, are you gonna make us reserve them? Do I need to go get a process server? We already have $1,500 in fees. I have over 100 hours in this case. John has 70-something hours in this case. We just wanted documents. And it's getting ridiculous. So are we gonna have to hire a process server now to go and serve them?
I don't think the law, I mean, process servers are required for summons, but I think anybody over the age of 18, including even lawyers, can serve a subpoena. As I understand it, the alleged defect here in the motions is that it wasn't personally handed to those witnesses. That I think instead it was delivered to like the front office of the DA's office, for example, since these are DA employees. And it was served mailed, I guess, by certified.
Certified mail, which is what the statute requires.
Right, was it return receipt requested?
Yes, and that's all that the statute requires.
And is it your understanding that no one has signed the return receipts?
Correct.
Okay,
And so it's left at their office.
right. And then also, I think I understand you to have served them as a courtesy by mail, even by email, even though we all understand that as yet, email service of a subpoena not acceptable, not
Exactly.
sufficient.
And we wanted to give them as much notice as possible. So as soon as Ms. Monroe told us that we were going to be forced to reserve the DA witnesses, we resubpoenaed them by email. We sent that all to them by email, offered, just like we did in the original email, if there's any confusion or concerns, reach out to us. The only response I ever got was, don't talk to me. Don't email me again. I mean, there's never been any discussion. We've tried to do this. But the law just says we have to serve them by certified mail. That's what we did. That's what the law says. And in their motions to quash, they cite one case. They cite Edenfield. Edenfield it actually supports our position. It was a law enforcement officer who was not served by certified mail. He was served by personal service. Someone went there, marshal, and tried to actually serve him in person, and they left it in a mailbox. So it was like an administrative mailbox. There was no proof that he ever got it. They admit in their motions that they received these. There's no question. There's no hide the ball. No one has hidden these. And the other thing that they argue is that it's oppressive to ask for all these documents at this point. These are the same documents, and that's one of the things I want to talk about is relevance, because they also argue that. And I think these go hand in hand, whether or not it's oppressive and what's the relevance. So I'm going to walk through these because this is sort of the elephant in the room. What are we asking for? All you've heard is it's oppressive. Why is it relevant? Why are these witnesses relevant? I'm going to tell you why they're relevant. I'm going to walk through all of them, why they're relevant. So we asked for essentially a couple different classifications of documents. You've heard a little bit about the critical mention documents, Judge. Those documents, and we've got some exhibits to show you, but the first one would be Merchant 0029, if you want to go ahead and pull that up. On January 18th, Shalonda Miller, who's the county attorney, and we filed all these. So when I refer to the merchant number, that's a Bates stamp number that we submitted, and so we'll be pulling those up. And I asked the county, and they said they would agree to all of these documents being admitted because they're all documents we received from the county. So, unless there's any objection to them, I'm planning on referring to these documents.
Ms. Monroe?
As I stated to her in the email, there was no objection.
Okay, so, great.
Okay, so this document, let's just take a look at it. So this is part of the packet. It's a 44-page packet that the county attorney sent me on January 18th, in response to my first open records request. If you look at 0055, so look at 0055, Judge, and look after Melissa Fritz, where it says Fani Willis, critical mention search.
Your Honor, I'm sorry. If I may interject here.
Yes.
There was a representation made by Ashley Merchant that these documents were provided by Fulton County, and the documents that she's showing on the screen as is was not provided by Fulton County, they were provided by the DA's office. So I wanted to correct the record as it pertains to that. In terms of my objections, I did not object to the business certifications that were submitted by the DA's office and Fulton County, all members who were subpoenaed in this action. But this document that she's referring to, the 44-page document, was not provided by the Fulton County, it was provided by the DA's office.
I understand why you're making that distinction for your record. I'll just point out that the continuing conundrum that these documents were produced not by the apparent only entity in the case that is actually governed, according to the defendant's position, by the Open Records Act. So either they were produced by the Fulton County District Attorney's Office or the district attorney, whatever legal entity that is, who by defendant's argument are not governed by the Open Records Act. But definitely they were not produced by Fulton County, who is governed by the Open Records Act. And I understand why you're making that distinction. I understand that y'all disagree with the court's ruling on your motion to dismiss. But anyway, I understand these documents were produced by the Fulton County District Attorney's Office. Is that correct? Okay.
And, that's part of the reason we need to talk to the witnesses, because, the letters that I get, one of the reasons I saw Shawn Miller under subpoena, the letters from her, and it's unclear to the recipient, the layperson who's requesting these documents, who gives them. Whoever gave them, this is what the county in general gave to us. So if you look at 0055, look at Fani Willis critical mention search, and then you look, it's cut and pasted. So this is not an original document. This is actually 4 or 5 different emails that someone cut and pasted and put together. We have now gotten, as of August 30th, the actual emails with the to and from, the dates, the attachments, but we did not get them back then. So we've got a cut and paste documents. I don't know who altered this. That's why I need to ask these witnesses. I have no idea who did this, but they cut and pasted. They didn't redact. They actually cut and pasted these documents to hide things from them. And if you look at.
Well, hang on. Let's be cautious about our characterizations. I understand that you are distrustful of what's been produced. Saying that it was redacted or that it was cut and pasted is a factual statement, but characterizing it as an intention to hide evidence from you is a little bit more of an argument that I would prefer that we not go down that road unless and until we need to.
And let me re-clarify that we have a right to question how this was compiled and why this is what we got in response to an open records request. How it was altered, why it was altered, who directed it to be altered, those types of things. Those are relevant to the open records inquiry, and that's why we need to question these witnesses. So as far as relevancy, this is just one of the examples. And I can show you if you want to pull up 0138 through 0140, what we received 2 weeks ago. This is the email. And then you see the attachment, critical mention screenshot. This is what we've been asking for 9 months.
Right, but I thought leading up to the September 5th hearing that I had seen some email traffic indicating that document, whatever that PDF was, had finally been provided to you.
On August 30th, yes,
Okay.
it was. And I actually wanted to clarify that. So since you brought that up, I'd like you to take a chance to clarify that, because the state did, I'm gonna mess that up again, I'm sorry.
That's fine.
The defendants, Ms. Monroe specifically, said that the brief update was that this case had been deeply rooted in the alleged failure to provide documents or attachments. And then she said the attachments were provided 9 months ago. As of yesterday, we learned it was not an issue of providing those attachments. It was whether or not the requester, us, had the ability to view the attachments. And that they argued to the court that there was nothing left to do. They said they provided the records 9 months ago with those attachments, and that it was very likely.
I remember that argument and your response that was not an accurate recitation of what occurred, and that you reviewed what was provided to you and it did not contain either the physical copy or an electronic link that would allow you to observe or view the PDF document. I'm not saying that's factually correct, but I am aware of that representation of what the defendant's position is and your response to it.
Well, that's no longer their position. So
Okay.
they have told us that they are not the same. The 44 pages we were provided in the open records is not the same as the 197 that were provided 2 weeks ago in the lawsuit. They're not the same. So that representation was not accurate and I think needs to be corrected. We were not provided those attachments. They said that they were in the process of reviewing and comparing the documents provided by the DA and Fulton County IT. 9 months later, they're in the process of reviewing those. So it's clear these are not the same documents. And that's part of why we're here. That's part of the litigation and why it's relevant to question these witnesses. What this whole hearing is about. Who supplied the 44 pages? Who decided what was in it? Why the other documents weren't provided? And what else is outstanding? What else is there? Because This was a contract, a media monitoring contract that was renewed by the county. It was so valuable, it was renewed, and they want us to believe that there were 2 reports for a 2-year media monitoring contract, that they had 2 screenshots, and that is the extent of all records from $20,000 spent to a company to monitor Fani Willis's image. I think that we have a right to ask them that on the stand, if that is really all of the documents that exist and what steps they took to actually find those.
So if we are limited to 6 people, and it sounds like more directly, at least as an initial matter, your focus had intended to be on 3 people, one of whom's job is clearly, like, that's his title.
Yes.
Is to comply with open records requests. Let's assume for a moment that I would agree with you that assuming that the nature of your questioning is narrowly focused on those issues associated with receipt and compliance and effort to respond, from a relevance perspective, what of the defendant's argument or the non-party witness's argument that these are, the need to question them is overburdensome or harassing?
It's not. These are published documents. These are documents that they are required to maintain. The law requires that they maintain these documents. So us asking them about these documents, it's very simple. These are documents that they have a public duty to maintain. The taxpayers paid for this. This wasn't something that was privately paid for. The taxpayers have a right to know what they're spending their money on. And this is just for critical mention. There's other classes of documents that we haven't even gotten to. But this is just for critical mention. These are open records. These are records that we're entitled to. I asked for them, I'm entitled to have them. There's nothing oppressive about asking them under oath, what did you do to find them? How do I know that I actually have all the documents? How do I know you didn't not give me something? Because we actually have proof that they didn't. We have a pattern already, because they gave 44 pages and they were cut and pasted, and then later on they gave us other documents. The documents they gave us on August 30th have some redactions in them. I still don't know what their redactions are. Why? I know what they are because they gave me the redacted information back when they gave me the 44 pages. I don't know why all of a sudden they decided to redact it. But we have a right to ask that. It's not oppressive. These are not difficult questions. It's not deep diving. They are public servants. This is a tax. The money, Fulton County paid for this service. We have a right to know what it is, and they have a duty to maintain it. So that's part of the issue. They have a duty to maintain this, and they have a duty to have these records, give us these records if we want to. I mean, that's the whole point of the open records and open meetings requirement. To be able to peel the layers back and see what's going on, see where taxpayer money is going. If you've got a district attorney that's asking for extra funds, saying I can't process rape kits, I can't do all this other stuff because I don't have any money, we have a right to know where that money goes. It doesn't have to be related to any case. I can just be curious. I'm a taxpayer.
So, I mean, I understand your argument. I mean, I think we should all take a step back though and be reminded that the Open Records Act doesn't require a showing of relevance. It simply requires a demonstration that the records are public. I don't think there's any dispute that the documents are public records. And the question really, to my understanding, is the extent to which they are maintained in the normal course, and to be produced when requested. And if they weren't, then why? I mean, that to me, I understand what your argument is, but respectfully, I don't need to know why you think those documents are important. What I need to know is, does anybody dispute that those documents are public records that would be subject to the Open Records Act? Which I don't think there's any dispute that there is.
And Judge, I agree. I'm arguing relevance because they brought that up in their motion to quash. They said that these items are not relevant. And so I'm trying to explain why they are relevant.
Right, and my point in saying I don't think we need to go there is that I don't think that relevance is a relevant inquiry in an Open Records Act litigation, because in a civil case, obviously, there's always a question of is this reasonably calculated to lead to the discovery of admissible evidence? What is the relevance of these documents? Are they material to the issues in the case? Here, the issue that those issues don't have to be reached if the documents are themselves understood to be public records. And again, I'm not aware of any assertion other than the argument that the district attorney is not governed by the Open Records Act, which is a different issue. I'm not aware of any formal interposition of an exception that these records would fall under, other than I think maybe I saw some informal communication about perhaps invoking work product or attorney-client privilege, which is one of the exceptions. But I think all of the formal responses and certainly all of the briefing do not assert that any of these records are subject to an exception, or that they are not in and of themselves public records. So I think we can move on from there and simply focus on the extent to which asking these witnesses questions when, because I think that's where the defendants go mostly, is that asking them questions at all when they've already said on a document, we don't have these records. I've looked and they don't exist, or I don't have them. That itself is the overly burdensome or harassing part.
Judge, I should be able to ask them if they've watched, because I don't believe they have watched. And so, and I know my belief doesn't matter, but I've submitted documents that exist in response that they have not provided. I've gotten them from other entities. So I have proof that they have not complied. So we have a right to ask them, how did you look? What did you do in response to this? And if I can go through, there's a couple, so let's talk about the confidentiality agreements. I asked for all of the confidentiality agreements that the district attorney's office required employees to sign. I requested that on January 9th in my open records. I followed that up on January 24th and said by letter, please don't make us sue you. I want the confidentiality agreements. I had one. I had Nathan Wade's. I had gotten it in another proceeding, and I had a business record certificate from Dexter Bond that it existed. Guess what his response was? No records exist. Well, so I've got a business record, which I've admitted, it's in the documents, a business record where he's certifying a confidentiality agreement from Nathan Wade, and then I've got the response in the open records that no responsive documents exist. So I should be able to ask him, why did you tell me no responsive documents exist when you were asked in a other case and you certified that they did? And now, just 2 days ago, I was given 22 additional confidentiality agreements. 10 months later, 22. I know more exist, but I was given 22. So pick and choose 22 employees in the DA's office who have signed confidentiality agreements. Jeff DeSantis, one of the witnesses we wanted to subpoena, gave a media statement that there had been confidentiality agreements signed in error and they were withdrawn. I followed up with that with another open records, making sure that they knew what I was talking about. You're giving the media a statement saying they exist, and then you're telling me in open records they don't. I have a right to question the witnesses about that. Why do I still not have those documents? I have 22 confidentiality agreements. I don't have them all. And I only got those 2 days ago. The next is, this is one of the most simple requests that the district attorney's office is actually required to do by law, keep a list of attorneys that work at their office. My requests, I think we've gotten lost in the weeds. They're not complex. They're not oppressive. I'm not asking for information I never in a million years thought in January that any of this was going to be a problem. I file open records requests all the time. I pay for the documents, I get the documents and move on. I asked for a list of attorneys and their dates of hire. Georgia statute and the record retention law requires that they keep those in their office. It is a misdemeanor not to keep that.
Keep what?
The personnel records.
Okay, but in fairness to the defendants, and I know that's one of the things they've asserted, if they don't have a list, right, they might have let's call it, they might have a file cabinet somewhere, probably electronic, of personnel files of the people who work in their office. I know you've mentioned, and I am familiar with the reports that the DA's office puts out that says these are all of our great people who are doing great work. But if they don't have a list, they're not required to create a list in order to respond to your request.
Correct, they're not. But what they are required to do is be reasonable in their response. So if they think, when I ask for the names of the people who were hired and the dates that they were hired, and that's something I know that they have, and they're not sure. They ask me, And I do this all the time, and they did this. The county attorney, actually, when they were responding to my requests, they asked me to clarify. We discussed it. They reached out to me, made sure that I was getting the documents I wanted. The goal of the Open Records Act is supposed to be to give the citizen asking for records the records. It's not supposed to be hide behind semantics. So if they're concerned because they're like, oh, are you asking for the names of the people who are hired and the date they were hired, which is what I asked for? If there's some confusion, they reach out to me. The goal is transparency. The goal is not to hide and obscure all of this. So when I asked for the people who worked there and the dates they were hired, I used to work for Fulton County. I know those records exist. I know what my employee file looks like. I also know that there's a statute in Georgia that says they have to maintain those. And so I'm asking for it based on what the law requires they maintain. They have to keep that. And I guarantee when they sent this to whoever produced this, they sent this to someone. There's a list that exists somewhere that has the names of the DAs. I can go to the state bar and type in the Fulton County DA and print out a list of the names. This is, they're forcing us to go through litigation to get a name and a date of hire, which is definitely maintained, and that's ridiculous. The other thing that we've asked for is, and by the way, just on that, the personnel, the Records Retention Act. So there's a statute in Georgia that requires, it's 50-18-102. It's a misdemeanor to not keep records in regards to what the Records Retention Act requires. The Records Retention Act requires that they keep personnel records for 50 years.
Now we object to this line because the Records Retention Act is not part of this case and I'm not relevant.
The retention is always relevant to the records judge.
So I'm not sure I understand the basis of your objection. I'm going to overrule it for now, because whether the county has the documents that have been requested, I think goes immediately to the extent to which they're obligated to have them. I agree that no one has sued or asserted a violation of the Records Retention Act, but to the extent that it's in the same title, it is informative about what the understanding and obligations that parties might have about those documents existing and continuing to be maintained. So to the extent that you're objecting that they're asserting a violation of the record retention obligation, I agree with you. We're not going down that road because that's not before us. But to the extent that that statute can be informative about whether the documents that were requested should still exist, I think I'm going to allow it. Go ahead, Ms. Marchand.
Thank you. And I'm not going down that path deep. It's just when I am asking for records, I have to make sure that they exist before I ask. I don't want to waste my time in an open record. So I use these statutes to ask for records. And when I'm told they don't exist, and I know the law requires they exist, that's concerning. And I have a right to ask follow-up questions to that. For example, on the personnel card, the law requires that the DA keep a list of all employees with ID cards. They have to keep that list. They have to maintain that list by law. If you have an ID card, and everybody has an ID card, I was a Fulton County employee, we all have an ID card. You have to keep that list, and you have to keep it for 4 years post-separation. So when they tell me they don't have a list, I think I have a right to not believe that. And I think that's why I have a right to question these witnesses. Where is that list? Why am I told that there's no responsive documents? Other places there could be responsive documents. The law requires they keep property receipts of everybody who has a cell phone. The district attorney's manual says that every attorney employed has to have a cell phone and a laptop. It's in their manual, it's required. The law says they have to sign a property receipt and they have to keep that. They have to keep a list of that. That would have been responsive to the request. And if they wanted to comply, they could have reached out and asked me, and I was willing to pay for any of these records. I pay them all the time for records. It's not a problem. I've never had a problem paying for county records. All they have to do is ask me. So the other area, the last area, actually the second to last area of documents and why these witnesses are relevant, this is all talking about why I should be able to ask these witnesses questions. I asked for forfeiture disclosure reports. The law requires forfeiture disclosure reports to be produced to state, local, federal governments. There are two separate forfeiture funds. There are federal money and state money. Two different acts. They have to comply with the Federal Forfeiture Act and the State Forfeiture Act. Every district attorney has to file a report with the prosecuting attorney's council every single year, and they have to file one with the DOJ every single year. I asked for those reports.
And those are not accessible to you publicly?
I got them by subpoena for,
No, let me clarify.
no, they're not.
They're not publicly maintainable in a database that's accessible to the public other than by requesting them through FOIA from the DOJ or from whatever entity maintains them for the state through an Open Records Act. Is that
To a certain extent,
okay?
let me clarify that because I want to make sure I'm completely accurate in my answer. The Carl Vincent Institute at the University of Georgia maintains some of them. They do not maintain all of them. In this case, the city of, the Fulton County actually misspelled the name at the beginning, and so you couldn't find it on there. So when I first actually asked for this, I couldn't find it because, and I had to call them and I ended up getting it through PAC, but I couldn't find them on Carl Vincent because they misspelled it. And so it's a search and it comes up by the county and it was in the wrong place. So it's not, but they're not all there. Some of them are there, but not all of them are there. So I asked for the documents from Fulton County. The point is,
Hang on.
Mhm.
You submitted, just to Ms. Monroe's earlier point, you just said you asked for them from Fulton County. And I know there's some discussion in the briefing that there was in fact one request that was formally directed at Fulton County as opposed to the district attorney's office. Is that what you're referring to? Or are you colloquially referring to Fulton County under the umbrella of you asked for these documents because they belong to an entity in Fulton County?
I think the best way for me to say this, I asked through the portal.
Okay.
I asked through the open records
So you
portal.
submitted a request through the portal for forfeiture disclosure reports for some period of time related to something.
Yes.
Okay.
And what they do, so it's actually changed. When I first asked for these requests, if you go to the DA's office, the landing page on the DA's office takes you to the portal. So back in January, if you go to the DA's office website, it has an open records link. It takes you to the portal, the county attorney portal. When you go to the portal, you submit your open records, okay? But you can start at the DA's office, but it bounces you to the portal. Then you put it in the portal. You can click down if you know the entity. You can click down, I want it from the district attorney, I want it from the county attorney. I'm over-inclusive because I've learned that I'm regularly told we don't have it, so I make sure to ask anybody who might have it. So I put it through that. 2 weeks ago, that open records link was not there anymore. Now it's back. So I don't know currently, I don't know why it's been changing, but when I submitted the request in January, I'm making representations based on how it existed then. I clicked on the DA's office open records link, it took me to the county attorney portal. And that's where I requested that. So I requested, on January 16th, I requested the reports and the itemization. The reason I requested the itemization, and I actually put the property, the funds obtained, these reports that are required by law, the statute actually says how you have to report them. And I will tell you, the ones that are on the Carl Vincent Institute, they don't comply with the statute. So they're not complete. So I'm assuming maybe they've got other documents because I'm assuming they're complying with the law. I'm asking for those. I'm asking for those forfeiture documents. I asked in January. Mr. Bond sent me a letter January 26th that said the records are attached. They were not. Only the equitable sharing, which is the federal summary, was attached. None of the state forfeiture documents, none of the ones that the law requires that they itemize were attached. Kept asking, been asking for 10 months for these documents. In the meantime, there's been media statements made by the district attorney's office that it was false and it was an error that any forfeiture funds were paid to any private contractors, Nathan Wade in particular. The forfeiture funds were used to pay Nathan Wade. It's clear from the documents that I got from purchasing and finance.
So again, I do not want to go down the road of what it is you believe these documents are relevant to, what use you plan to put them to. The issue before me is the testimony of these witnesses relevant to your public records request? And again, absent having heard anyone assert that an exception applies or that these documents are not public records, then to me, the issue is the extent to which you are questioning of any witnesses about their processes and efforts to comply. As long as it is narrowly focused on that issue, I think you've met your burden for relevance to the public record request. Not, because again, what you think they might be useful for or why you want them. My understanding is it's very clear. The reason that a member of the public requests a document has nothing to do with anything.
I completely agree, Judge, and the reason that I was pointing that out is because when statements are made about documents that I've been told don't exist, that causes me to think I need to question a witness. If you're telling the news that a document that I've requested and you tell me doesn't exist, you're making statements about them, that leads me to believe that they do exist. So that's why I want to question Mr. DeSantis, because he's made statements about documents that I was told don't exist, that I do believe exist. So that was it. And I'll move on. The last one, though, is the promotional materials. So if these things, they're paid for somehow. And I was very specific about all of these. If you walk into the DA's office, there's big wall hangings, things like that with, rebranding. There was this whole rebranding campaign. I asked for how that was paid for, like rebranding, payment, requests. I tracked the statute. So the statute, and the reason that that's relevant, tracking the statute, is because I know they're required to maintain these. The law says they're required to maintain these. And so because they're required to maintain this, and it's an open record, and I'm told that they don't exist now, I think I should be able to question the witness as to why they don't exist. If they don't really exist, under oath, the law says that they've got to include all the accounts payable, bank statements, all of this stuff, deposit slips, canceled checks. They have a duty to maintain that for 5 years pursuant to statute. So where are all of those documents? And I was again told they don't exist. They have to exist or else, they should exist. I guess maybe they couldn't exist. Maybe they didn't pay for it. Maybe these vendors donated this out of the goodness of their heart, whoever printed this. Maybe the taxpayers didn't pay for it. I don't know. But that's why I need to ask the witnesses. And the last thing I'd point out is to relevancy. It goes along with the paycheck or the accounts payable. I asked how critical mention was paid. I've been asking for 10 months how it was
Can
paid.
you finally get it? I think in some of the documents I saw,
For critical
a check,
mention.
like a handwritten check.
Yes. I still haven't received that. They still not even admitted that account exists. I got that from critical mention. The reason that that's relevant is because part of what you have to decide is if they have been hiding documents, obscuring, keeping things from us for 10 months. Did I have to file a lawsuit to get that? Did I have to waste all of my time to get that document? I still wouldn't have it from them because I still don't have it from them. They're required to maintain that. They're required to keep canceled checks. I still don't have that from them. I had to file a lawsuit to get it. So it's relevant for you to inquire as to whether or not they've complied with the open records request, for me to ask about that. So I think all of these things, Judge, are why we should be able to question these witnesses. Thank you.
Thank you, Ms. Merchant. Who am I gonna hear from first? Ms. Alavi or Ms. Monroe?
I'm happy to go first, Your Honor. Thank you so much.
I'm sorry, Your Honor, do you mind if we pause for a small bathroom break? I really have to use the restroom.
Sure, no problem. We will take, it is 10:56. We're gonna take a break until about 10 after 11.
Thank you.
Yeah, one moment.
That's where she went.
So start now. It's about 50 minutes.
No, I mean, I'll take it. That would be responsible.
Sure. I no longer work for the full finance shoes.
I'd much rather be here. Much rather be on the badge. Although I live with packages at 4 to 5 and 6.
That's why.
Period.
one will be the podium mic and L2 might have. Okay. So, doing the best I can. They'll give us audio out.
Is it everything on the side?
Yeah, you can copy your card. Is there anything interesting happening?
Yes, they arrested a witness on Friday
Yeah.
at the hospital talking about people transfusions.
Yeah.
Spent the weekend.
So-
Then,
And then his attorney said
he went to
yesterday.
Grady. So he's been at Grady ever since. So like he's supposed to testify this week. Allegedly he was released from the hospital today and they might have put him on the stand with medics on standby.
Was that the guy that they weren't sure if he was at the hospital or if he was in jail?
Yes.
They couldn't figure
He's
it out.
technically in custody, but like.
There's always something happening with that. Yeah. It's funny, stories about cat trying will get flagged to like my bosses or whatever. Do you have that times? Does anybody every day? There's something
Yes.
getting caught back
And I
up.
try to like take in things like, oh, it's not 2 weeks. After the 3. The 3 weeks and 2 months.
Not really.
No. This is interesting. How about it then? This is the high voltage.
Oh, yeah.
The one where the line was, it just wasn't great. Just to be clear. Like if it was Joe Bell, I think for volunteers, I don't
They asked us for help with the shooting game, last week, that locker. Yeah, already.
need it for council order.
Okay,
Ms. Alani, where did we leave off?
thank you, Your Honor.
And I'm sorry, Your Honor, before we do go officially back on the record, I just wanted to address everyone to remind them Zoom makes this just a little bit harder for me. So if we could please make sure that we're speaking maybe a little bit slower than we normally would and directly into the microphone, that would be a huge help.
Absolutely.
Thank you so much.
Thank you. Go ahead, Ms. Alani.
Thank you, Your Honor. Judge, I filed these motions to quash on behalf of the non-parties, Jeff DeSantis, Paula B. Bailey, Kevin Armstrong, Jeremy Murray, Jasmine Dilligard, and Dexter Bond. And we filed these motions under OCGA 241323. And we're filing these motions and believe that these subpoenas should be quashed because these employees have not been properly served. They have no firsthand knowledge of relevant issues with regard to the open records matter before this honorable court. I'm going to put an asterisk next to Dexter. He's a little different, so I'm going to separate him out from the other employees. And
I know that your motion is also procedurally differently cast regarding him. Is that right?
yes, that is correct. And you talked about that a little bit with plaintiff's counsel with regard to Mr. Bond having knowledge and being the business records custodian for the office. So his motion is filed as a release from the original, what I call the original subpoena, the one that was received via email on August 2nd of this year. And so his is a little different. And the subpoenas are unreasonable and oppressive. And as I just stated, on August 2nd of this year, the plaintiff emailed a number of subpoenas to members of our office. Those subpoenas were subpoenas for the production of evidence. They did not require witness testimony. Specifically, each email contained a business record certification, which we, each individual, Jeff DeSantis, Paula B. Bailey, Kevin Armstrong, Jeremy Murray, Jasmine Dilligard, and Dexter Bond completed those business record certifications along with the responsive documents, and did provide that to counsel and to this honorable court. And we subsequently, on the 13th of September, last Friday, did receive via email to one or more of the individuals previously aforementioned, another subpoena for the production of documents along with a witness subpoena. But I want to note for the record that that subpoena is different. It asks for different information than the one in which the original hearing started on September 5th of this year before this honorable court.
What do you mean different information?
Different information is contained therein. So the first subpoena, the subpoena dated August 2nd, 2024, asked for 4 items, all emails and text messages concerning critical mention, etc. Second, all emails and text messages, including links with regard to attachments with critical mention. Number 3, PowerPoint presentation identified as media relations executive team presentations for November 30th, 2021 PowerPoint. And then number 4, and lastly, for this particular subpoena was an analytics graph. The email subpoena that was received by members of the office dated September 13th from the plaintiff's firm asked for 7 things. It asked for critical mention emails and texts, checking account information through a Wells Fargo bank with an account number, confidentiality and non-disclosure agreements. Number 4 is forfeiture documents. Number 5, attorneys hired and dates of hiring. Number 6, promotional material. Number 7, rebranding material. Different. We've already started this proceeding. We've already had some arguments with regard to the issues contained therein, and then we get an email saying that we're going to receive certified mail with yet another subpoena asking for different things. And so I'll talk a little bit more about that when I get to the overburdensome portion of this argument. The subpoenas that we acknowledge receipt of, because there was never consent or agreement or waiver that the emails from August 2nd were properly served. However, District Attorney Fani Willis, members of our office, we always try to ensure that individuals that reach out to our office have the things that they need. Transparency is a touchstone of who we are as prosecutors. We take a special oath to ensure that individuals that come before us or who contact our office are serviced well, that our constituents know that we are there for them, and that we are doing everything that we can to get them the information they are looking for. So notwithstanding the fact that counsel has yet again failed to properly serve members of this office with a valid subpoena, we did
turn over the documents that were asked for. My motion does not go into whether or not there was proper service with the August 2nd subpoena. At this point, it's inconsequential. She has the information. The information has been provided. We have done that. We have complied. At this juncture, we have satisfied the terms of the subpoena. Subpoena asks for documents they have. And so at this point, there's nothing additional that is needed. And I will note for the record that during the September 5th hearing, there were two individuals that joined the Zoom, Ryan Holmes and Andrea Geiger, with critical mention. And less than 5 minutes into that hearing, according to the timestamp on the Zoom video, those individuals.
For the record, not an official court record of the proceeding that occurred that day.
Yes, ma'am.
I understand that we can all use it as a reference point. Just to be clear, not an official court record.
Absolutely. Those individuals were allowed to be excused as their business record certifications were sufficient. They did the exact same thing that we did. They provided business record certifications with the information that was provided, that was requested from the plaintiffs. They provided that, and they were excused.
Right, and in fairness, and I don't mean to imply that I agree with plaintiff, but I think plaintiff's position is they had no reason to question the complete compliance with the request that was made to critical mention. And again, I'm not saying it's fair or justified, but the plaintiffs have made a great deal of hay of the fact that they question the completeness of the representations from various witnesses, that in fact, all responsive documents have been produced in response to the Open Records Act.
And I recognize that. And I say this in the least flippant way possible, but plaintiff's assertion that there is a belief that she is not receiving all of the information does not make that a fact. It does not make it true. It does
I
not make
agree
it.
with you, but the plaintiff has to some extent been able to point to independent documents received from other entities, like for example, critical mention, that would seem to indicate that additional documents should exist. Maybe they don't anymore. Maybe they're not in possession of somebody. There might be lots of reasons that they weren't produced in response to the Open Records Act that aren't willful or in bad faith. But I think in fairness, the plaintiff has pointed to third-party documents that would seem to indicate that those documents did exist at some point.
And I think in fairness that there has to be a look at the totality of the circumstances. The district attorney's office is not the IT custodian. We only have access to records to a certain date. We do not contain, or have a database that is big enough to keep every single email, every single correspondence, every single document that may have been received within the office. That is literally why we have an IT department. And so if we do not physically have it within our office, we literally, not even 6 months ago, had a cyber attack with this county. And so this assertion that there is a disbelief that there's some nefarious intention, or that we are hiding something, that we are intentionally trying not to give documents or information to the plaintiff or anyone else, is quite frankly just not accurate. Our track.
So here, look, I'm gonna back us all up again, and I continue to do this, I'm gonna do it again, because both sides are doing it. We are here because a member of the public requested from a government agency documents about that government's operations, right? And so the intention behind that request, the purpose that might be intended to use those documents, none of that, to my way of understanding how the Open Records Act is supposed to work, none of that is relevant. What is relevant is the extent to which the government agency should have those documents and should respond to those documents. And one of the things that's presented an issue, and that's one of the reasons I stopped and went back to this, is that I have no doubt that you are highly knowledgeable about the operations of the district attorney's office, but technically you are here on behalf of non-party witnesses. And I think it would help if, when you are talking about the motions to quash, if you talked about the specific witnesses that have been subpoenaed and why they should not be subject to subpoena. I understand some of those issues that go across all of them, and let Ms. Monroe and Ms. Bowman argue about why Fulton County and the Fulton County District Attorney's Office writ large and or Madam DA Willis do or don't have those documents. And do you understand the distinction that I'm trying to make for a moment?
I do, but
Okay.
with one caveat, Your Honor, the law for service of subpoenas literally states that subpoenas are not supposed to be used to harass individuals or to, to use those subpoenas maliciously. And I do think that that is a point that needs to be made, especially during this proceeding, considering that the usage of subpoenas in the way in which they are used has been done with an intention to harass, to oppress, to malign the name, the character of not just the individuals that are contained, these non-parties, but also the district attorney herself. And so I would be remiss not to note that, and that the law does give guidance with regard to how subpoenas are supposed to be used. The individuals that
Fair enough, Ms. Lobby, but here's the thing. I completely understand why the defendants in this case, given the arguments that Ms. Merchant has made, that I've, again, tried to get us away from, and let's focus on, these are public records, that's all that matters for now. I understand why the DA's office might feel that these proceedings and these efforts at public records requests are designed to harass the DA or the DA's operations. What I don't understand, though, is how is a subpoena to an individual whose job it is to comply with Open Records Act requests on behalf of the DA to come and testify about what efforts he took to comply with an open records request. How is that harassing?
Judge, the individuals, the non-parties, Jeff DeSantis, Pallavi Bailey, Kevin Armstrong, Jeremy Murray, Jasmine Dilligard, are not those individuals that are tasked with responding to open records. Their job duties, what they are assigned to do within the office and what they have been doing has never been that. They are not the business records custodians. They cannot talk about in the court, put it very succinctly, the receipt, the processing, the efforts made to process those requests. Those are not the individuals that can provide that information to the court.
I agree with you, except that, again, I think what I think I understand is that the reason that the plaintiff chose to subpoena those individuals is because after being told there were no documents by the official people, they received some documents that, for example, emails that included Mr. DeSantis, that included Mr. Armstrong. And so then the plaintiff said, well, if Fulton County, writ large, the DA, whatever, all these entities, right, to whomever that request was directed, says they don't have them, well, now I want to ask Mr. Armstrong or Mr. DeSantis, were you asked if you had these documents? I mean, and again, the reason I'm trying to narrow this down is because if these witnesses were to take the stand and Ms. Merchant were to attempt to engage them or question them about matters that don't have anything to do with the request at issue and their association with that request, then I would agree with you, that would start to be harassing. But it's my job to narrow the scope of any witness's testimony to the matters that are properly before the court. And that's why I think this is the third time I keep coming back to this issue of these are public records, a request was made, there was some effort to comply with the request, which the plaintiff has asserted was incomplete and therefore is seeking to enforce. And so, as I understand it, the plaintiff wants to ask these witnesses, what effort did you make to comply, or were you even asked to provide documents that would be responsive to the requests that I made?
And I understand the court's position with regard to that, but we are feeling around in the dark here. We have assertions that have been made that are not facts, that are not evidence. There has been no witness testimony that has been given. There has been no indication that what plaintiff has asserted is true, correct, that it's anything other than some assumption that there is some nefarious intention.
Well,
she has.
Ms. Amati, okay. There are two reasons we haven't heard from any witnesses. Number one is there were motions to dismiss filed by all four of the entities who were sued, right? Which automatically created a stay of discovery. And number two, no witnesses have testified because the witnesses have all asserted that they're not subject to subpoena or that they don't have any information. So there might be, at the motion to dismiss stage, the court was required to, and did, rely only on the allegations of the pleadings. And I will say, many of them weren't disputed, right? It wasn't disputed that these were records that would be public. It wasn't disputed that there's a portal operated by Fulton County. I mean, there's lots of things that weren't in dispute, but the court was limited to the pleadings, the allegations and the pleadings. The purpose of today's hearing is to have some actual evidence, to hear from witnesses with knowledge about the nature of this request and what efforts were made to comply with it.
And those individuals, as discussed in the last hearing, have been designated. We know who those folks are. Dexter Barnes Jr. is one of those folks. Shalonda Miller, Deputy Counsel, is one of those folks. But those folks still are not Jeff DeSantis, Falabi Bailey, Kevin Armstrong, Jeremy Murray, or Jasmine Dillard. They have never been considered to be those folks in the discussions and the hearings that were had on the 5th. Their names never came up as individuals that would have information that would better inform or edify this court as to the receipt, processing, or efforts made to process any open records requests or responses to the subpoenas. And so because of that, there has been no dispute in that in the argument that has been presented to the court. And because of that, and the other individuals have fulfilled and satisfied the request for the production of documents, because that's what it was, a request for the production of documents and not a witness subpoena. What we're asking this court to do, at the bare minimum, when counsel comes before this honorable court, we are required to do certain things. And properly serving an individual is one of those things. That has not.
I understand, I agree with you, the email isn't sufficient yet. One day I guess it will be. Why though, in this particular context, was certified mail combined with an effort to deliver the subpoena into the hands of a responsible person who would then provide it to. And the reason I ask that is certainly we don't want to live in a universe where the requirement is that individuals personally go and find individual ADAs or individual employees of the DA's office to put a subpoena in their hand when what they're being asked about is their work. And instead, accommodate the delivery of a subpoena to a responsible person who will then place it in the hands of the individual who works at the DA's office, given particularly that the DA's office is a limited access location.
No one has ever reached out to me in order to serve these subpoenas. I serve as legal counsel for the district attorney. What efforts have been made to do that? Certified mail, we have no certified mail. We've not received anything. I literally accepted service on behalf of Prairie Swift just the other day, the week before last. There's not an issue with service in our office. We get served you'd be surprised to know, we get served all the time. So there's not an issue with service within our office. I don't understand why plaintiff wishes to be treated differently in executing the basic and fundamental duties of any attorney. I shudder to think with this court, how this court would view, rule, or decide in a case in which the state brought forth a case and did not properly serve our witnesses. That is our duty, it's our obligation. Counsel mentioned that we are members of the bar. We sure are. We need to act like it. Serve your witnesses. We do not have service. We do not have anyone who, to my knowledge, who has come to the office. I've not been contacted by the merchants at all in order to receive service. Our chief investigator has not. That has not happened.
What about what about Ms. Merchant's representation? And forgive me, I don't know if it's in the briefing that I read at 6 o'clock this morning, or if it's in email traffic that crossed with my staff. But what about, or even today in her argument, but what about her argument that I announced that this hearing was going to take place today? Everybody agreed that the hearing would take place today. I clarified that any subpoenas, any witnesses that were under subpoena continued to be under subpoena with the expectation that they would appear here today. And at no time until about 6 o'clock this morning did those witnesses say, oh, I was never served, oh, I'm not subject to that subpoena, other than the prior representation that had occurred overall, where most of these witnesses said, I've already complied with the subpoena because I've said I don't have any documents.
Judge, I think one, service, I was not involved in the previous hearing. I thought that was discussed, but it sounds like it was not, that improper service, because I saw an email stream with the plaintiff and Ms. Monroe talking about whether or not the individuals from our office needed to be reserved. And so.
Right, I'm aware of that, but I also know that during that hearing, I said, I understand that I'm not releasing these witnesses from the subpoenas that brought them here today, and that I strongly encourage the parties to engage in good faith efforts to agree. And instead, the defendant's counsel took the position that, no, you have to serve these individuals, but then does not acknowledge the email notice, the certified mail, and the delivery to the office of the Fulton County District Attorney's Office, which is, again, a limited access location. I cannot, even as a judge, walk into that office without pushing a buzzer and saying, please let me in, I'm here to see X. And so I suspect that no one, had the plaintiffs hired a process server, et cetera, would have been able to walk into the DA's office. I understand your representation is that they could have contacted you and secured service potentially, or acceptance of service or whatever on behalf of these individuals.
Or they could have come to the front desk. We're open for business 8:30 to 5 every single day, Monday through Friday. We are not cordoned off into some, secret cauldron of some sort.
Perhaps I misunderstood, but I thought the representation was that that's what they did, and they delivered the subpoenas to some front office worker.
That was not my understanding of that, and we do,
And I apologize if I misunderstood.
We have not received anyone to our front desk on behalf of this matter that I am aware of. The certified mail receipt that was attached to the motion that was filed by plaintiff's counsel, there was an indication that there was a mail room or a front desk of some sort. I don't see an address on there. It does not say the district attorney's office. I don't know if it was delivered to the library. We have no way of knowing what efforts were actually undertaken in order to facilitate service, other than we don't have good service. We were not served. There was no indication that anybody came physically to the government center and to the district attorney's office in order to effectuate service.
Okay, so are you arguing that the representation made by the plaintiff that they served by certified mail and attached copies, that those are somehow not accurate or authentic?
I don't know what they are. I don't have anything that shows, proves, verifies that whatever counsel is representing made it to our office, actually made it to our office. I don't have that.
Okay.
And
So let me ask you this. So let's say that I disagree with your assertion that the testimony that might be sought from these witnesses is overly burdensome or harassing or not relevant. But I potentially share your concern about a lack of service, right?
Yes, ma'am.
Given that there's no dispute that these witnesses are aware that they were being requested to appear, right? To my knowledge, there's no dispute that these individuals, given your appearance here today, also given at least one of the witnesses contacting my office saying, hey, can I please be excused until later in the day? Then why not simply acknowledge service and let's start over again in the morning and actually have the evidentiary hearing that was intended to be had and about which everybody had noticed since September the 5th?
I think there's a particular irony in asking that of the state, the non-moving party, when all counsel is not asked to do their jobs, right? We have a duty. We have requirements that we have things that we are required to do as attorneys. And one of those fundamental things are making sure that we have the people there under the proper mechanisms that are outlined in the law in order to be there. There's no requirement on behalf of myself as legal counsel, District Attorney Willis, to waive anything. We do not, that's not a requirement of us. And quite frankly, with all of the vitriol and negative assertions and just the gamesmanship that has been taking place in this case, why would we? We have complied with the
Because, as you said a
subpoenas.
moment ago, almost everybody involved in this case is an attorney who has a professionalism and civility obligation to each other, to the profession, to the court. And again, I fully appreciate and understand that there's lots of gamesmanship, and I don't mean to apply because I know that I don't mean to imply that I don't see some of the gamesmanship coming from the plaintiff side. I understand your concerns, but again, that's why I keep trying to pull us back to, this is a public records request that was served in January, right? Or maybe even before then. Maybe we just got to the point of where's the answer in January. Maybe it was even before then. I don't remember exactly as I sit here, but it's September of 2024. And the plaintiff is taking the position that they still don't have documents they've requested, that the DA's office, whatever we're calling that entity, would have an obligation to produce that are public records, and there seems to be a lot of delay here, a lot of effort to keep pushing backwards instead of making an effort to simply get to the substantive issue, which is, do these documents exist? And if so, why were they not produced? Or do these documents not exist, which is why they were not produced, and therefore why the plaintiff has no claim, no further issue to pursue. And that's what is frustrating the court, and that's what I think y'all both sides should hear at this point, is that this is supposed to be fairly straightforward, and the gamesmanship about which you complain, I'm concerned is being engaged in by both sides. Because it's not that hard for these witnesses to come and say, I got the request, this is what I did, I gave them what we had. Here's what efforts I did when they said, this isn't enough, or I think you have more. These are the additional efforts I made to locate them. Those are legitimate inquiries. And the idea, when there's no dispute that the DA's office has, and when there's no dispute that the defendants and the non-party witnesses who are associated with one or other of the defendant entities have notice of the subpoenas, both from this court stating we were going to have a hearing where I expected witnesses to be called who had previously been identified, to a certified mailing notice, to a courtesy email. And then my question is, well then, okay, why not just acknowledge service, or let's adjourn the hearing, have the merchants walk across the street, give all the subpoenas to the front door window of the DA's office. And is that going to be sufficient? What I'm trying to figure out is, at what point do we get to the merits of this? Because one day we might get to the merits and I might say, you know what? I think the DA did everything they were supposed to do and tried to find all the documents, and they just don't have them, and that's okay, and they didn't do anything wrong. But we'll never get there because everybody keeps throwing up roadblocks to have a conversation about the actual merits of where are these documents and what efforts were made to locate them.
I understand the court's position. I do. I would say that what the court uses roadblocks are our assertions of the law. We look to the law and we look to see what remedies are available to us under the law, and we follow the law. And that's what we have done in filing these motions to quash. That's what we have done with regard to responding to an improperly served subpoena in order to not engage in gamesmanship, in order to give a member of the public what they have asked for. We have communicated with plaintiff's counsel. We have asked for clarification on a number of issues. We have received, yet again, subpoena after subpoena with requesting different information. And we have asserted our legal standings, our legal rights, and we have followed the law and what we are to do when we are presented with these issues.
And I don't fault you for asserting those issues at all. I mean, that's your job and you're right? Like you're entitled to say we were not properly served. If I agree with you that service did not properly occur, then that's where, we'll deal with that. But respectfully, you didn't actually answer my question, which was when I said, well, why not just accept service now and let's get to the merits tomorrow? Instead of saying, okay, or no, because you just said, well, I think it's rich for them to, ask the court to go forward and force y'all to do something without observing the legal niceties when they haven't observed the legal niceties. And so
I think I respectfully disagree with your assertion or recharacterization of what was said. My position is we are here and we have been requested to produce certain things. All we're asking is that we have an even field, even requirements, that everybody who walks into this courtroom is treated the same. That when we come in, that we are prepared to proceed with our case. When counsel comes in, they're prepared to proceed with their case. And if we are not properly served, if the law is not followed with regard to whatever it is that is asked of us, the law is not followed, if we drop the ball, then there is that next step, whatever it is that flows from that, we own that if we mess up.
Right, but again, so that again begs the question, what happens if I adjourn this hearing today, say we're gonna start again tomorrow, and the plaintiffs take their subpoenas and come over to the DA's office and physically hand them to the front office?
Then we're served.
And then we can all have this substantive hearing tomorrow where I have a completely free open day.
Your Honor, like I told you earlier, we get served all the time. This is not something that is unique to our office, unique to my role and my position within the office. We literally get served all the time. And so for that not to happen, not just once, but twice in the same proceeding, at what point do we say, hey, we all have a job, a duty, responsibilities? We should.
Forgive me for interrupting, I'm sorry. Technically, even if those subpoenas from August 2nd and previously were not served properly, that objection was waived by the fact that the individuals responded to them, right? I mean, they filed some sort of answer saying they acknowledged service, whether they formally acknowledged service or not. Most of those witnesses did respond to the subpoena by saying, here's a custodian of documents saying I don't have any documents. So I think we're focusing our efforts on the subpoenas that were served in advance of this hearing, correct?
Yes.
Okay.
But I bring up the August 2nd because it appears that the same methodology or tactics were used, even though that was at issue on the August 2nd. And so instead of there being the extra step to reach out to myself or to reach out to someone else within the office to say, hey, we're trying to make sure that this gets to you guys so that you, one, have it, that you know what the scope is, that we can have those discussions as the court has.
Which presumably they did by emailing it to you, but.
And let's talk about this email that we received on Friday, at the end of the day on Friday, to produce voluminous, I imagine, because we haven't even had a chance to take a look at these things, produce voluminous documents mid-hearing. We're literally on a pause from a hearing that started on September 5th, and the game changes on us. We get served with, we get emails because it's not even proper service, new subpoena, new information is requested, it is voluminous, and then there's that added, an additional request that we have multiple members of this office come in to testify to something that we have already certified, to something that we have already provided, and we're not even given a sufficient opportunity to respond really to anything other than what we have provided by way of the business record certification.
I'm not sure what do you mean you weren't given an opportunity to respond to anything? That's what I'm not, I mean, aren't you doing that now?
No, I'm talking about with regard to what's been requested in the September 13th email subpoena.
So Ms. Merchant during her presentation did not go into detail about the nature of the documents being requested in the subpoenas, or, you know, the areas that the witnesses were being requested to testify about. What she did, the way she framed it, is that the still open public records requests that they made related to critical mention documents, a list of attorneys, forfeiture disclosure reports, and promotional materials or rebranding materials, that those are all open, and to her mind, I understand this, the defendants disagree with that, open records requests that have not been responded to or fully responded to. And so I think to the extent that the subpoenas contain be prepared to testify about X or produce documents regarding X, the idea is that it would be in service of those 4 items, not that it is a new public record request, I think, and maybe I'll hear from the plaintiff differently.
Okay.
Because what I hear you, what I hear you saying, and that's what I'm trying to understand is, are you arguing that this is a new public record request? Because I'm not sure, I mean, formal Open Records Act public request.
I'm arguing that this is a new subpoena. It is. This is a new subpoena, has a new date, it has new information. It's requesting new and different information from the individuals that are named here. So that was,
People serve subpoenas in advance of hearings all the time with relatively short notice and say, be prepared to, testify about these things. Because these issues aren't new, right? A subpoena is, but the issues aren't new.
but the request to produce these documents, with 72 hours notice for all payments, requests, vendor applications, invoices, receipts, promotional material, brochures, flyers, mailers, that's just one enumeration, right? To compile, to research, to compile this information takes longer than that. There's a research period if this had been served properly, though it is not. But this is the overburdensome type of subpoenas that we continue to receive. And then to ask that these individuals take time out of their day away from serving the constituents of Fulton County, our victims, our individuals who have been affected by crime, in order to come in here and testify with regard to this. Your Honor, that is what makes this request, this subpoena of a sort that should be quashed as a matter of law, not just for the lack of service. But there are individuals, like I said previously, who have already been designated as the individuals who keep the records for the Fulton County District Attorney's Office, for our county, who know how these requests are received, processed, and the efforts made, as the court has stated. Even plaintiff's counsel herself indicated that Dexter Bond, Shalonda Miller, those individuals, she also included Jeff DeSantis, we disagree with that, but those are the individuals that will have the information that is relevant to the issue before this court. This should not be a fishing expedition where as much information as possible is trying to be obtained in order to help in the adjacent criminal case. That's not what this should be.
I agree, and as I have said multiple times, this case is, despite the subtext that all of y'all seem to be aware of and seem to keep deferring to, which I understand why it frustrates both sides. This is a Public Records Act, an Open Records Act action. It's an action to enforce a request for open records, and that's all it is. Now, what somebody might try to do with those records and why they're being asked for, that is not my concern, and I'm trying real hard to keep it out of this proceeding because it does not control the outcome and it should not concern the court. Now, I also fully intend, whenever a witness actually takes the stand, to keep the nature of any inquiry very narrow to the issue here and not let the plaintiffs engage in some sort of fishing expedition that doesn't have to do with the public records request that they asked for and that they are seeking to enforce. And so, what I'm trying to, let's see, this hearing started at 9, well, I guess we started late because we had to get a court report. So it started at 10 o'clock. We've been going roughly 2 hours and we still haven't gotten to the where we need to be, which is the subpoenas. I except to the extent that it's my intention to limit the scope of any inquiry of any of these witnesses to the very narrow issues that are presented. I disagree with you that these subpoenas are overly broad or unduly burdensome, given that everybody had an understanding of what was going to be at issue for some time. Now, I think your best argument is probably that they weren't properly served, but that is something that can be remedied through either one, the parties civilly and professionally agreeing to accept service, which I can't compel anyone to do, or by securing service today in advance of the substantive hearing that this case should have already had by now. And so what I'm wondering, Ms. Alavi, is does that if I tell you that I disagree with your position that the subpoenas are overly broad, but that I might agree with you about service issues, but that service issue can be resolved, then does that resolve your issue, understanding that you continue to disagree with that ruling? But it would ultimately be a ruling denying your motion to quash on the basis that it was overly broad, but perhaps granting your motion to quash on the basis that it wasn't properly, specifically served in the exact manner on the individual required by law. What are your thoughts?
I still think, and based on my motion, that the individuals listed for the non-parties, minus Mr. Bond Jr., they have no relevant information with regard to the issues that are before the court. They are not the custodian of records. They are not the individuals that are tasked with determining how those records are received, what we do with them, how we process them. The efforts that we made for diligent searches, they are not those individuals. They just happen to be individuals that may have sent an email or received an email. They are not the individuals that can speak to how open records are handled within the office. So
Right, and I think I understood both Ms. Merchant's statement here this morning and also cross email that I saw, that Ms. Merchant, I think at the beginning of this hearing, identified 3 witnesses that she intended to call. One of whom is Mr. Bond, right, whose job it is to deal with open records.
understood.
And that I think the discussion in the email communications that the parties copied the court on was that the only reason that they might need to get into the weeds of these other witnesses is if those 3 witnesses say, that document doesn't exist, when they have documentary evidence that an email was sent to somebody. And so part of the issue is, as I said earlier today, regarding the motion to quash the subpoena to Madam D.A. Willis, the motion for contempt, I should say, is premature because nobody's actually tried to call Fani Willis to testify in this case, in this proceeding. And I wonder if the same is true about those extraneous witnesses, because it may be that their testimony would be cumulative or immaterial to the proceedings, depending on how the testimony of those 3 witnesses that were initially identified by Ms. Merchant. And please forgive me, I know Mr. Bond was one of them, I don't remember the 2, maybe Mr. DeSantis and one other person.
Yeah, Ms. Miller.
Ms. Miller, thank you. So if we were to proceed with, at some point, with Mr. Bond, Mr. DeSantis, and Ms. Miller, does that also address part of your concerns, Ms. Alabi, on behalf of your clients, other than what I know you're going to perfect for your record, right? That those individuals have already signed documents saying we don't have anything else responsive. But does that satisfy at least part of your concerns about the nature of what's sought from them for this proceeding?
The nature of what's sought from them.
The nature and scope of the testimony and documents they've been asked to provide.
I would still object to Mr. DeSantis being called as a witness for the same argument that I've made a couple of times now. He does not have any relevant information concerning anything that has been before Your Honor. Mr. Bond Jr., quite frankly, is the one who has the information. He's the one who has the knowledge of how open records work within the office. He is the best witness. He is, quite frankly, the only witness that can really testify to the mechanisms that we have in place within the office in order to ensure that individuals that reach out to us and wish to receive open records receive them. And so I would still ask this court and move this court to quash the subpoena with regard to Mr. DeSantis. Mr. Bond testifying, I understand that, Your Honor, which is why I separated him from the pack at the onset of this argument, because he is differently situated and he does have information that would be helpful to Your Honor. But the other individuals that I have filed these motions on behalf of, they just don't. That's not part of their duties. It's not part of their job. It's not something that they've handled. they don't have that information. And so, because of that and based on that and all the arguments, before now, we would ask this honorable court to quash, these subpoenas on Mr. Bond if council wishes to do that and, get that testimony, but the other individuals are not the proper parties.
Okay, but to be clear, only after he's properly served with a subpoena, correct?
He will testify.
Thank you, Ms. Levy.
Appreciate it.
Ms. Milrow?
Good morning. Yes, good morning.
You've got 4 minutes to still be good morning.
Okay, so I just don't want to belabor the court with just duplicative arguments. As it pertains to Fani, Madam DA, in her official capacity, we filed this motion to quash subsequent to plaintiff's motion for enforcement and contempt. And also to Ms. Fani Willis is not the person with superior knowledge who can speak to the things that I believe is before your honor.
Well, let me save you the trouble. I agree with you,
Yeah.
right? I mean, as I said, we are in the civil world. Most of y'all probably spend most of your time in the criminal world, but we're in the civil world. And in the civil world, there's a pretty well-established doctrine that says that we don't ask the CEO for documents until we've gone and asked the people whose job it is to have that information. And in this situation, by extension, the analogy here is that Madam DA is the CEO of this entity and that there are people like the individuals whose job it is to provide these documents, to comply with these requests and to talk about how they're maintained and how they go about responding. So save you the trouble there. I agree with you that there's a limited universe in which what particular knowledge Ms. Willis has about the nature of this request becomes relevant, but we're nowhere near that point yet.
Right, and so that's where the harassing part comes in. I do believe that these subpoenas were issued not for the information, not to seek information as it pertains to the underlying request, because the underlying open records requests were submitted to the Fulton County District Attorney's Office, not to the DA in her official capacity. The people who can speak to those things, to the process.
In fairness, let's be precise. The requests were made through the portal that is maintained by Fulton County to the Fulton County District Attorney's Office. And the only reason it became an issue that Fani Willis, as the District Attorney of Fulton County, did not receive those requests is because the drop-down menu on the portal says Fulton County District Attorney's Office, and then Fulton County District Attorney's Office said, we can't be sued to enforce this request because we're not an entity. So that's how we got here. I don't think you gain anything by arguing, well, the district attorney was never served with this request, because the request was made in the manner that requests are supposed to be made, in that the portal was used to submit it to an appropriate entity that would have custody of these records. So I don't think that helps you, so maybe move on to a different position.
And just to clarify the point, the reason why I brought that up, and testimony from Deputy Shalana Miller and Dexter Bond can actually clear up that process and how it actually works as it pertains to Fulton County and the District Attorney's Office adjacent and by way of use of the portal. But as it pertains to DA Willis and the process of open records, from receipts of the request, how it's handled, down to the request itself, and how it's provided, she wouldn't have any particularized or special superior knowledge as to that. And so in the interest of judicial economy, we want to make sure that we have witnesses that would be competent to speak to those things, who would have personal knowledge that would speak to those things. And to have DA Fani Willis here to speak to those things would not be that. So.
But here's the thing. One, DA Willis is not here,
Correct.
right? Two, if I am presiding over a trial, right, the lawyers will typically subpoena 8, 9, 10 witnesses, right, if they think they can get through that many in a day. And I would never, ever hold a witness in contempt for failing to appear if nobody actually called them to the stand and then they weren't there in compliance with the subpoena. So that's number one, which is why the motion to hold Madam DA Willis in contempt, in my opinion, is premature. By extension, I think the motion to quash at this point is moot because nobody's actually called her to the stand. I've already said my belief based on the case law is that the plaintiffs are going to have to make some sort of showing as to why her testimony would be specifically relevant here. That doesn't necessarily relieve her from the obligation to potentially be subject to the subpoena, to be under subpoena. And I don't know that I can make an informed decision about the nature of any individual information that Ms. Willis may have, unless and until I hear from witnesses and the plaintiffs make some showing that the only way we'll ever answer this question is to hear from Madam DA Willis, which, as you can probably tell from my tone, pretty high bar. So I mean, I don't know if it's that. I mean, to my way of thinking, the motion to quash is not something that I'm going to entertain right now. I'm not going to relieve Madam DA Willis of the possibility of having to testify in terms of being under subpoena for this proceeding. But from an evidentiary and court management perspective, the court certainly reserves the right to say, no, I'm not letting you call that witness. That testimony would be cumulative. It would be immaterial. There's any number of reasons that I might never need to hear from Madam DA Willis on this particular issue. And so to me, all of those matters, as I started with this morning, I think are premature at this point. And so I'm happy to let you continue to make your legal argument for your record about why Madam DA should not be subject to the subpoena and that the subpoena should be quashed. But ultimately, I don't expect I'm going to give you a ruling on that unless and until the rubber hits the road and somebody actually tries to call her to testify here.
Okay. So we reached out to opposing counsel to inform them that she was not going to be present at this hearing. They've alluded to the fact of who would be testifying, but in terms of making DA Fani Willis subject to a subpoena that she hasn't been served with, that is the second part.
That's a different issue, right?
That's the second part of our motion. So
But one question, so
Yes.
help me understand factually, is the subpoena that was delivered, we're gonna try and use a different word than served, because I understand that's a disputed issue right now. Is the subpoena that was delivered for Madam DA, right? Does it fall into the same category that it was sent by certified mail and an email was sent, but it was not delivered to the front office or in any personal way? So same exact process, is that right?
Yeah, so we have ongoingly checked with the DA's office to see if service was received by Madam or the office, front desk, as they alleged, in their pleadings, and that has not been the case. When I did a checking of the USPS tracking that they provided in their exhibits, I think it's Exhibit G, in their certified return receipt mail receipt, it just says Fani Willis, doesn't provide an address. And then when I look at the tracking, it says could be at front desk, mailroom. It has all these slashes of all the places that this certified mailing could be.
Well, but if certified mail is allowed, right? If certified mail is an acceptable way to serve a subpoena, and it was mailed to the address, right, that someone I think I understood Ms. Merchant to say that it was return receipt requested. So someone signed the return receipt?
That is not my representation,
Okay.
that if someone signed the receipt, all I know is that in tracking the certified return receipt that the plaintiff alleged was sent, that it was confirmed that it could be delivered at the front desk, mail, which is all different places within Fulton County government. The front desk and the mail room
Being
are,
someone who's subject to getting my mail through the
okay, it's
Fulton
all
County
different
processes.
places.
But I guess my question is there really a dispute that the subpoena was mailed to an address at which one could expect eventually
Yeah,
the DA
it's
to
still something
receive?
that she has to receive, and she was not in the jurisdiction to receive it.
Well, okay. If it was properly mailed to an address that's associated with the DA, where the DA expects to receive mail, if certified mail is sufficient, isn't that sufficient?
It's my understanding that it's not just a certified mailing. Once you've done the certified mailing, the person that it's certified mailed to would have to accept that certified mailing. You can't just leave it at the front desk of someone's home, leave it at the front desk of someone's office. That person would have to have received personally that certified mailing. I would not be able to accept certified mailing on anybody from my office. That's just not how it works.
I think we need to talk about that a little more. I'm not sure that that is accurate. I think that if personal service is required, then personal service is required. If service by mail is allowed, then delivering it to the address where that person or entity is known to receive mail potentially would be complete service. Because otherwise, then really you're just engaging in an extended effort at personal service. If the argument is, once it gets certified mail delivered to, again, to my analogy of the CEO, the mailroom of the Ford Corporation, right? And the Ford Motor Company, and then it's got to go through 17 hands before it actually gets placed in the hands of the secretary of the CEO. That would defeat the purpose of allowing certified mail of a subpoena, would it not?
Well, the thing about a subpoena that it subjects the actual person to do something, the actual person. So absent some sort of express consent from that person who is named in that subpoena is not, that service of that subpoena is not enforceable. The court does provide some direction on this. In the Edenfield versus State case, it says that the lack of personal service invalidates the legal force and effect of a subpoena. So whether it be hand delivery or certified mail or overnight mailing, that person in which who is the receipt of those mail is the person who must receive that mailing unless it gives a third party consent to do so in order for it to be enforceable.
Okay.
That is my understanding of the interpretation of the statute.
So by that logic, let's play it out to its natural conclusion. The DA was not in the state of Georgia on Friday, when I think someone has told me that Friday which was Friday the 13th, how fitting. That Friday the 13th was when these subpoenas were mailed to, or delivered in the mail to the district attorney's office, right? Is that correct?
That's right.
Okay. And so by your logic, because Madam DA Willis was out of town on Friday, that subpoena could never be served on her because she wasn't here to receive service of a certified mailing to her office where she routinely receives mail.
Well, that's assuming that it was sent to her office. And that's correct. If she was not there to receive it in person and she did not provide express consent for it to be received on her behalf, that is not proper service.
Okay.
And also too, I failed to mention in the first part of my argument, in terms of the substance of the subpoena. If the court can recall, there were two subpoenas served, actually three subpoenas that were issued by the plaintiffs, in that the first one was for the production, a slew of production of electronic communication regarding critical mention. Then we have an alleged witness subpoena, which never took place. There was no witness subpoena. There was only a subpoena for the production of documents, and that was something that I raised at our last hearing.
Right.
And we had some discussions about whether or not we were going to incur additional costs as to effectuate service on those subpoenas. And I did raise the challenge that what plaintiff was alleging to be a witness subpoena was not in fact a witness subpoena. It was a subpoena for the production of documents. Now, with a witness subpoena, you're supposed to provide the scope of testimony. In either cases where, in any of the subpoenas.
Not necessarily. So a 30B6 deposition notice or subpoena, you have to require, you have to provide a sort of a list of areas of inquiry so that the entity can make sure that it's got one or more people sufficiently prepared to testify on behalf of the entity. But here, the scope of the questions are limited by what's relevant in the context of the case. Now I understand it might have been accompanied by subpoena requests for documents, but the scope of the testimony that might be offered or expected to be offered by any individual under subpoena is, controlled by the scope of the case.
Okay, so to that point, which leads me to my next point, you have subpoenas for the request of documents that are not the same as the underlying open records requests. They do not mirror each other at all. Yes, there are key terms such as critical mention, forfeiture reports, analytical reports, but they're not the same exact requests or searchable items. So we're essentially, what plaintiff has done here is opened up a whole new compartment of information that originally she wasn't entitled to. And so now we have a slew of subpoenas to what started out as from 16 individuals to now 11. That's harassing. That is harassing within itself. When you know that there are designated individuals,
Can you
officials.
clarify that for me? Because
Yes.
Ms. Merchant represented when she first started arguing that there really still are only 6 people. And yet I've heard the number 12, I've heard the number 11. I don't know, but I would love to know the answer of, are there 6 or are there 11?
Okay, so from what I can recall, and I believe this is all part of the court's record, but there was a notice of filing of subpoenas. And I
Yes.
do believe that there were a list of somewhere around 16. Don't
Yes,
quote me, and I would have to just double check
That is part of the record. It is, for my benefit, I'm going to say this. There was a notice of filing subpoenas filed on August the 30th. It's docket number 48 in my record. So yes, and there were a number of individuals, all of whom, I don't know if it was that they were provided to plaintiffs and they filed them or if defendants filed them, but it looks like Bond, Willis, DeSantis, Bailey, Dilligard, Armstrong, Kerrigan, Murray, that is the list, but they all filed some sort of response and objection to the subpoenas that were served on them.
Yes, sir, and I was the one who filed those objections
Thank
on their
you. Okay.
behalf. And also those responses, hoping that it would resolve it. However, it became a moving target where, oh no, we're not talking about critical mention documents anymore. We're talking about all these other things, rebranding, promotional materials, list of attorneys in their hiring dates. If you compare, and this, once we get to the hearing, Your Honor, we'll be able to view the open record request individually, precisely as to what was requested and how they were responded to. And also, we can also compare them to the actual subpoenas for production of documents to see what was requested of these individuals, why these individuals were even selected to request these things. I mean, I have a subpoena from Miss English, and she's someone I didn't even file a motion to quash for, because at this point, it was just completely out of hand. But I said, you know what, her testimony or getting her here, I do believe is irrelevant as it pertains to the subpoena, all because she missed one email. To have her be subject to a subpoena I've never heard of that type of practice before. But this is how the plaintiffs have decided to practice in this matter, by subjecting all these people to subpoenas who they know that do not have access to that information. Ms. English, who is a member of External Affairs, she does not work for the DA's office. She wouldn't have any information regarding the DA's bank accounts. I have a subpoena in front of me here where she's asking from checking accounts from critical mentioning contracts and DAs from the DA's office. Why would Ms. English have that information? A member from External Affairs. This is why I say it's harassing. She's asking members.
I don't know the answer, but I think my review of the initial requests were that these individuals are people who would have handled or been involved in branding and media relations such that they might have knowledge of documents that existed that have not been produced by the DA's office. Even though, again, I agree with you, probably not their job to be in charge of those documents. But if they know that they exist because they had them at some point because they were sent to them, or maybe if it's External Affairs, if it's your job to send that out into the world, right? But now,
But what
the
about
DA's
for,
office
yeah,
has said, I'm
so
sorry.
what about forfeiting documents? What about attorneys hiring dates for hiring? Like, why would someone from External Affairs have that information?
So I don't disagree with you, but that's not a reason to say that they're not subject to subpoena.
No,
That's
I'm saying that because they're not, I'm sorry.
That's a reason to say the scope of what they're asking this witness is excessive. I want you to say they can only ask them X, Y, and Z. And what I've said, I think a couple of times relative to various witnesses, and certainly Madam DA Willis, is that you kind of have to trust me that I know what's relevant in this case and that I'm not going to let people go on a fishing expedition. That I'm just going to say, ask them about the open records. And if that witness, if they get asked a question about bank records and you stand up and object and say, this witness works for External Affairs, she would have no knowledge, and I'm going to go, that I'm going to sustain your objection. I mean, so much of this is subjective about how this evidence is going to come in and about what is relevant to the scope of this hearing, this proceeding, which is, are the records public records? Were they maintained? Were they requested? What efforts were made to provide that?
I completely understand the court's position. I guess because we're so closely tied to this case, we know the ins and outs of it. And we know that if your sole purpose is to obtain information, there's a comportment, there's a posture in which you do so. And plaintiff has not taken that posture. In fact, they're using this as a platform to create a show. This is not about gaining information. This is purely about harassment. And I'm not shy to express that to the court. And I understand how the court may differ on this point.
It's not that I differ. It's that all of you are talking about the fishing expeditions and the harassment and the gamesmanship that I can see on both sides. But what I am telling you is the law does not support that as a basis, right? The questions that a court is to consider on an open records enforcement action is, are the records public? Were they requested? Were they produced? And if they were not produced, why were they not produced? Why the person wants them is not a relevant consideration, even if I think that the only reason the person wants them is for harassing reasons. That's not a relevant consideration. And so I understand your frustration, but again, I think we are wasting each other's time by continuing to talk about the gamesmanship and the harassing nature of this exercise, because I kind of agree with all of you that this is both frustrating and gamesmanship on all sides, and probably going to be used for some harassment or whatever on the back end. But my concern legally within the structure of an Open Records Act request is, are the records public? Which doesn't seem to be in dispute. These are public records that would be subject to the Open Records Act. Were they requested? Also doesn't seem to be in dispute. And were they produced? That is in dispute. And if they were not produced, why were they not produced? Also in dispute. And now, if we narrow ourselves to those issues, then it just feels like we can move this case forward to actually consider the substance rather than this, which seems to be they're trying to harass me, so I'm not going to agree with anything they ask me, and vice versa. They're not agreeing, they're putting up roadblocks, so I'm not gonna agree to anything, right? And that is not the way that we all want to conduct ourselves.
I understand, Your Honor. Just to close, in terms of, Your Honor, we're not trying to belabor this point any further. We do understand that we have a hearing to get to, and we have individuals here who can testify to the merits of this case in a way that is efficient, in a way that is substantive, and in a way that can bring this case to a speedy close without all the extras. And those two individuals are Dexter Bond and Shavonna Miller. We stipulate to the point that that documents weren't provided initially, and as what the hearing will display, it will get into the request, it will get into who received the request, it will get into how the request was processed and how the request was responded to. But I would just ask the court, in the interest of judicial economy, and to make sure that we are actually getting information that will be helpful to the court to consider, so the court can have an easier job in hearing the case on its actual merits versus the narrative that the plaintiff wants to produce to the court.
Okay, so thank you, Ms. Monroe. A couple of questions I have for you before you have a seat, and then we will move on. Essentially, same question and it maybe to Ms. Alavi, I'm not sure, but I think I understood that for the limited purpose of moving us forward, that Mr. Bond would be willing to waive that insistence on formal service and be available to testify today. Did I understand that correctly?
Yes, Your Honor, and I would ask this court to reserve ruling on my motions until such time as Mr. Bond does testify, and see if that settles your mind with regard to the other individuals, non-party.
And that was my intention. My next question is, what about Ms. Miller?
Yes, Your Honor, she's
She's
here.
willing to,
Absolutely, we did file a motion to quash on her behalf.
okay, just want to make sure. Okay, thank you.
Thank you.
Ms. Merchant?
Yes,
Very brief. Since it was your burden, I'm going to give you a chance to reply, but please be brief.
I promise.
We've been beating this horse for 2.5 hours.
I understand. First, Dexter Bond was personally served of the city, so didn't know that was a big dispute. Should have brought that up earlier. We have his return. So he was served, so I'm not really sure why they're arguing it's not served, we have the return.
It doesn't matter because his counsel on his behalf has said he will waive service to the extent it was defective in any manner and testify today.
And Judge, I always have planned on calling Dexter Bonds first and calling Shalana Miller second, and then calling Jeff DeSantis, and I can enunciate exactly why I believe Mr. DeSantis, and if we get to it, Ms. Willis, would be relevant. The critical mention piece is there's a private password and a private app. Dexter Bonds was not involved in that at all. Never had it. You can tell from the emails. If you look through the emails, he did not participate in that. He signed the check, but he did not participate in that. And you can see that from some of the email traffic where he's talking to Jeff, and he's like, I don't even know what this is. They're asking about critical mention. What are they talking about? Jeff DeSantis is the one that had that account. He can answer the questions about the maintenance of the reports. Dexter Bond, I don't believe he can. Maybe he can, but I don't believe he had personal knowledge, because only the only two DA employees that actually had access to critical mention are Fani, Willis, and Jeff DeSantis, which is why they were understood now. So I think that he is relevant for that reason. I think that will become abundantly clear when Mr. Bond testifies. Bond did not have access to those reports, those types of things. That was not part of his job. So Mr. DeSantis would have that. The other thing is, I just wanted to clarify for the court, the same thing with the reports and the analytics for critical mention. The only people on those reports and on those emails are Fani Willis, Jeff DeSantis, and then a former employee who does not have access anymore, Robin Yerty. And so those are the only two. There's an email specifically, it's at Merchant 0095, June 4th email, where Ms. Willis is emailing Mr. DeSantis and Ms. Bryant, talking about she's waiting on things from critical mention for a book. And they're the only people on that. So I can't ask Mr. Bonds about what stuff they're waiting on from critical mention, what documents exist. Mr. DeSantis is the only one, and Ms. Willis, that I can ask about that. As far as the motion to enforce the subpoena, I understand the court's not happy that we filed that preemptively. The reason that we did, just to clarify, is because recently there was another subpoena issue, and the court's order in that case said to preserve the right to call that witness, you had to moved to enforce the subpoena. So out of an abundance of caution, as soon as Ms. Monroe said, Ms. Willis is not showing up, we moved to enforce the subpoena to preserve that right, once they let us know that. As far as, the only other thing that seems to be a theme is that this is oppressive and harassing. These are all the same things they've been asking for since January. They're not oppressive and harassing. I just keep hearing that term without any explanation as to how they are oppressive and harassing. I'm asking for documents that are public records, taxpayer-funded records, and we've made concessions. We've been asked to make 2 concessions on witnesses. We were asked to release Miss English. I agreed. I said, I don't think I'm going to need her. Can she be on call? And we don't care if she comes by Zoom because I don't think I'm going to need her. They asked me that. They asked if Mr. Kerrigan could have a substitute because he's at a conference. That's fine. I told them exactly what the testimony would be that I would be questioning so they could prep that witness. We've not been unreasonable. I emailed every single witness that we subpoenaed and said, talk to me. Most of them emailed, if they did email back, just telling me, no, thank you. But if there were any questions, we've tried to be accommodating. So the only request we had, we even were willing to accommodate Ms. Willis to testify by Zoom once we found out she was out of town, and we were told no thank you to that as well. So we're not trying to harass people. We're just trying to find out where these documents are and why we're not being given them still to this day. So I just hope we can move forward, Judge.
Okay.
Oh, and Judge, we've got all the subpoenas if we need to reserve them. Ms. Alavi said, I have copies of them. She's emailed. She can have my originals. I can hand them to her right now. She said she'd take notice of all of them. So we can hand her all of those. Previously, Ms. Monroe had said she, and I would just state also for the record, when I did reach out to witnesses, I was told in no uncertain terms that Ms. Monroe represented them. So we didn't serve as a Ollie because we didn't know. This is the first we heard when she filed this. So I had no idea. Like, Ms. Monroe was the one that was representing them. We served Ms. Monroe with all of them. We copied her and everything. We didn't talk to any of these witnesses without Ms. Monroe being copied. But I'm happy to hand those back over. Additional copies of these witness subpoenas. Happy to.
Okay. I think I've made it pretty clear what my thoughts were in reviewing the filings by the parties and trying to get to what are the merits of a very narrow issue, which is, are these public records resolved? Were they requested? It appears they were, but maybe if there was some confusion about the nature, I can hear about that. And if they were requested, were they produced? If not, why? It sounds as if we have agreed that we can try to move forward with Ms. Miller and Mr. Bond regarding the merits of, did they receive requests? How did they get processed? What did they do to comply with the requests? And what did they do to produce? And then as Ms. Alavi requested, I will reserve ruling on the motions to quash the subpoenas of the other witnesses unless and until, and that includes the subpoena to Madam D.A. Willis and the motion for contempt for her to not appear, because I think those motions are premature unless and until those witnesses are called to testify and I say, yes, I would like to hear from them. Because it's possible that Ms. Merchant might say, I want to call insert name of other witness. And I say, why do you want to call them? And I then am allowed to say, I don't really think I need to hear from them because I think it would be immaterial or cumulative of testimony I've already heard. And so unless and until she calls a witness that may or may not be under subpoena formally, and I say, yes, I want them to take the stand, I don't think I need to rule on either the sufficiency of the subpoena in terms of its service or the scope of what was requested in the subpoena, unless until that issue is presented to me. So I will accept your invitation, Ms. Alavi, to preserve or to reserve ruling on those motions to quash until such time as I have to, until I think they're right. So it is 12:30. We've been going since this morning. What I'd like to do is take about a 45-minute break so we can all refresh ourselves and clear our minds and maybe get some food so we don't fall over from hunger, and then get started at 1:15 with actual substantive testimony and hearing, okay?
Thank you.
Anything else I need to address before we adjourn for 45 minutes?
No, Your Honor.
Thank you, Your Honor.
Thank you.
did you pull out in front of me like that, lady? Like, what in the world? Okay.